Welcome to Data Driven, new research puts spotlight on migrants' rights. Thank you all for joining us today. My name is Alexis Fentland, and I'm currently a senior in the School of Industrial and Labor Relations, minoring in Migration and Latino Studies. I'm also a member of the Migrations Scholars, an incredible group of undergraduates passionate about migration studies and research in collaboration with the Migrations Initiative. Thank you to Cornell University's Migrations Initiative for hosting this discussion. This interdisciplinary initiative studies how all living things migrate from place to place on our planet, and you can engage with more of this work through upcoming activities this semester. Thank you also to the Cornell Law School for co-sponsoring this discussion today. As we begin today's program, I would like to first acknowledge the land which we are on today. Cornell University is located on the traditional homelands of the Guyacono. The Guyacono are members of the Haudenosaunee Confederacy, an alliance of 6 sovereign nations with a historic and contemporary presence on this land. The Confederacy precedes the establishment of Cornell University, New York State, and the United States of America. We acknowledge the painful history of the Guyacono dispossession and honor the ongoing connection of Guyacono people, past and present, to these lands and waters. This acknowledgement does not exist in the past tense or historical context, but with the recognition that colonialism is a current ongoing process, and we need to build mindfulness around our present participation. For today's event, Professors Ian Kissel and Stephen Yale-Lair of Cornell Law, along with Professor Justin Guest from George Mason University, will apply data to show how effectively states are protecting migrants' rights and complying with international law. Now I'm excited to introduce Professor Stephen Yale-Lair, our moderator for today's event, who will also introduce our other speakers. Professor Yale-Lair has practiced immigration law for over 35 years. He is the co-author of Immigration Law and Procedure, the leading 21-volume treatise on U.S. immigration law. He also teaches immigration and asylum law at Cornell Law School as a professor of immigration practice and is of counsel at Miller Mayer in Ithaca, New York. Professor Yale-Lair currently serves as one of the faculty fellows leading the Cornell Migrations Initiative. Without further ado, I will turn it over to Professor Yale-Lair. Thank you.
Thanks, Alexis. And I'm really happy to be here today to moderate this discussion and to introduce my 2 friends and colleagues. First, Ian Kissel is a visiting assistant clinical professor of law at Cornell Law School. He founded and directs the Transnational Disputes Clinic and co-directs the Asylum and Convention Against Torture Appellate Clinic. Ian is also a founder and director of the International Migrants Bill of Rights Initiative, which you'll hear about during this webinar. And he's a core faculty member in the Migration and Human Rights program at the law school. And he's also a non-resident fellow at the Zolberg Institute on Migration and Mobility at the New School. Ian's research focuses on public and private international law, including international law and human rights law and U.S. immigration law. Second, Justin Guest is an associate professor of policy and government at George Mason University's Sklar School of Policy and Government. He studies immigration and the politics of demographic change. He's the author of several books, including a new one that's just coming out. He also co-edits the Oxford University Press book series called Oxford Studies in Migration and Citizenship. And he works with Ian on the International Migrants Bill of Rights Initiative. If you have any questions, post them in the Q&A, and I'll moderate the questions at the end of the presentation. But for now, I'll turn it over to you, Ian, to start our slideshow.
Thank you, Steve. Thank you, Alexis. And thanks for joining me today, Justin. I also want to recognize our colleague, Sergio Garcia Rios in the government department here at Cornell, who couldn't join us today, but is part of the team and has been a great support in some of the research that I'll be talking about. So I want to give an overview of the talk. Talk a little bit about the International Migrants Bill of Rights Initiative and some of the legal research work that anchors our advocacy work, our kind of theory of change, and then 2 particular research projects that I'll talk about in more detail. One, the Migrant Rights Database, which is the first effort to develop an empirical account of how states protect migrants' rights, and the new compendium project that we've launched with the support of Cornell's Migrations Initiative that seeks to provide a more descriptive encyclopedic account of how state practice engages the international baseline and support arguments about customary international law. I'll discuss both of those as we go forward. I want to start by giving us some context and grounding us in three puzzles that motivate this initiative and the work that we'll talk about for the rest of today. So first, our mobile world, the migration of human beings, pushed, pulled, both older than the organization of political communities into states, the elaboration of the individual rights that we'll talk about today at the international level. And in the background here, you'll see a loop showing global net in-migration over the last half century or so. So what you see here is in the darker shades, countries that are receiving more migrants in a given period. And I find this striking in a useful way to contextualize this issue of our increasingly mobile world, because the map shows the magnitude both of south to north migration, but also south to south migration patterns in recent decades. Of course, in absolute terms, the number of international migrants across our globe is at an all-time high. We hear a lot about the many migrants crossing borders. The most recent estimates at the beginning of the pandemic were about 272 million international migrants. That's up from 153 million in 1990, and more than 26 million refugees and asylum seekers, up from about 19 million in 1990. Now, it's important, of course, to emphasize that as an overall share of the global population, the number of total migrants is not radically different than it was in 1990. It's up to about 3.3% from 2.9%. But nonetheless, there's an increasing number of international migrants. And I think that global climate change, these dynamics will drive them to become more complex. It's not entirely clear what the total impact will be on the number of international migrants and refugees, but it is clear that there's likely to be substantial change and increase in climate-induced outmigration across national borders. And so as to puzzle one, then, this increasingly mobile world, I think it's clear that the dynamics of global migration flows will only increase and become more complicated. So that's really the first puzzle that we're tackling in this work. Now, this puzzle makes it all the more complicated that the next two puzzles remain. First, there is no single treaty that regulates or manages migration or articulates the rights of all international migrants. So there's a gap as to rights. There's not even actually a widely agreed upon definition of international migrant in international law. There is, of course, a definition of refugee, which has a very particular meaning and covers those who flee persecution. And two regions, Africa and the Americas, have expanded on this and recognized that those fleeing conflict are also included in that definition. In 1990, the United Nations opened up an ambitious treaty on migrant workers and their families, and we can speak more about that treaty in the question and answer period. It's failed to gain widespread ratification and hasn't been ratified as law by a majority of the states that receive the largest numbers of migrants, but it is an important effort. But nonetheless, overall, the work here is set out because there is no single treaty. And that's the second puzzle that we tackle. The third puzzle is that there's no international organization whose role or mandate is to facilitate and manage migration among states in the globe. The International Organization for Migration, or IOM, founded in 1951 to assist with displaced people in Europe, has a limited mandate set by member states, and it's only recently come into the UN system in July of 2016. It's historically been an organization, as suggested by the history of its founding in the Second World War, that's really been tied to particular migration dynamics and specific funding streams allocated by member states. And most importantly, it doesn't have a human rights mandate. The UN hasn't had any particular organ whose role was to facilitate migration or the cooperation or regulation of migration. There's a UN Office of the High Commissioner for Human Rights, which has a global mandate when it comes to all human rights in all places. Of course, they do important work on migration, but it's not an operational organization in the way that you might think. And there's the UN High Commissioner for Refugees, which you may be familiar with, that has an operational mandate, has a mandate anchored in the refugee protection regime, but doesn't have a general mandate to protect the rights of all migrants. And At the regional and bilateral level, there are a number of mechanisms to manage migration flows, but overall, again, on the governance piece, this is also incomplete. So in many ways, these are three important puzzles that anchor this work. And as you think about the rest of the presentation, I'd encourage you to keep on coming back to these touchstones. And I think we only have to look at COVID-19 and the related border closures to really understand the scope of the problem here. We have the vast majority of UN member states close their borders without even an exception for asylum seekers at the height of the pandemic, and states have struggled to have any kind of coordinated response. So let's stop this animation at 2017. So to engage these puzzles, what we've done over the last decade or so is develop first what we call the International Migrants Bill of Rights. It was a legal drafting exercise to try to articulate how does this patchwork of treaties that regulate different areas of human rights come together around the experience of migrants and account for essentially a global baseline of protections, whether drawing from refugee law, labor law, general human rights law, law regulating smuggling or trafficking. And what we did is build a legal research case for how the treaties that states have already concluded regulate a core set of rights for migrants. We also articulated this research case as a kind of international treaty, differentiating between areas where we saw the law reflecting existing binding commitments and areas where we saw the law evolving, and differentiated then between things that we thought states had undertaken to provide, which we denoted as things that states shall do, and things that we thought that states should do because maybe they were already doing it in one or two regions or a particular national case that was promising. So this work has grounded a kind of theory of change in the way that our research and advocacy engages the migration field. It starts from an insight into the nature of lawmaking, the idea that although states have organized themselves around key treaties protecting rights, that in these areas where there isn't kind of unequivocal language in a treaty, that we can help harden the interpretation and recognition of international law by articulating what could be called a soft law. It has various different definitions, but in our context, we see this idea of a Bill of Rights as something that could be articulated by intergovernmental organizations, networks of civil society, and used as a rallying point for bringing states to recognize the core commitments that they've already made to migrants through their commitments in general international law, and to help those duties harden and become more firm and fixed in state practice. Also see this as a way to help continue to push the progressive development of the law, to encourage states to adopt progressive trends from other nations, from other regions, and broaden the protection of rights of migrants. And we've done this through a couple of key partnerships. First, we worked closely with colleagues at the international level to help inform the drafting of most recent international non-binding work on migration, the Global Compact for Migration. It was adopted through the UN system a couple of years ago, and we worked with missions to the UN to help influence the way that certain rights issues like non-refoulement, discrimination, detention, and due process were captured in that document. But at the regional level, we've also partnered with the Inter-American Commission on Human Rights, helped them adapt our Bill of Rights into a set of principles on the rights of all migrants, and are now working with the African Union's Commission on Human and People's Rights to do the same, all reflective of this insight that by collaborating and helping, in this case, regional human rights bodies, encourage the crystallization, if you will, of a Bill of Rights for migrants, that we can create new tools to help states comply with old obligations, and in that way help promote the protection and recognition of the rights of all migrants. So for the rest of the talk today, we'll focus on a couple of our more research-oriented projects that have really significant policy implications. And the first one is our migrant rights database. This is the first global database on migrants' rights, and we've built it, expanding it now by using a set of novel indicators that are based on the international baseline. So trying to benchmark how states around the world reflect this idea of a migrant's Bill of Rights, reflect their international obligations towards migrants in their national law. And the goal of the work really is to answer a basic research question that's that addresses a kind of empirical gap in decades of law and practice, which is, well, how do states actually protect these rights at their national level? And we were seeking to provide the first cross-national data set that allows comparison between countries and on a range of rights. So this is a project that we began with World Bank support, piloted that. Justin has led the empirics of this work, and we'll hear from him in just a moment, and then have been able to code to 36 country cases covering about 80% of the world's migrants with support of the Swiss government. We're planning to expand this database to 45 country cases with more support from the Swiss in the years to come. So let me turn it over to Justin to talk a little bit more about the methodology.
Thanks, Ian. Thanks so much to Cornell Migrations for hosting us today. Very grateful I had the opportunity to share this research with you guys. In many ways, what we're trying to do here is to thread the needle between the analytical rigor that a lot of previous studies of immigrants' rights has really reflected in trying to understand exactly how national law protects immigrants and their human rights. On the other hand, we're trying to also balance relevance. We want to have the scale so that we can actually put each country's protections into a global context. And so to do that, what we did was, it was a challenging thing to scale, which was to create 65 binary indicators, which makes things easy and scalable to study. But still, it's a lot of indicators that cover 17 different categories of migrants' rights. And all of these rights and all these indicators are derived from the really hard work of the lawyers behind the International Migrants Bill of Rights Initiative and the Bill of Rights. And so what we did is we simply adapted the various rights that should and shall be covered by countries and their governments into a way of studying the extent to which they actually are. And of course, by doing this, we're actually able to create a baseline of understanding what the baseline is around the world by using these kinds of scalable indicators to fill that data gap. On the next slide, you'll see here that the methods that we use are really quite rigorous. So we, all of our coding from our attorneys who do the coding, and by the way, these are all independent attorneys who are specialists inside of the countries that they study. We hire 2 per country, and we ask them to code the various 65 indicators with legal citations. And what that does is not only derive how they make the decisions for their citations, but it also means that it can serve as a sort of resource or a reference point for lawyers and activists in the future who are trying to better understand the coverage of migrant rights in the different countries. The lawyers that we hire are independent, meaning that they are not working for the government, that they are coding, so they can actually act as fair referees and objective referees. They also code double blind, meaning one coder does not know what the other coder is coding until we ask them to reconcile any discrepancies that arise in the coding. And that also leads to the reduction of intercoder reliability bias and an insurance against it. We also ask the coders to code both the de jure or de jure protection of migrant rights, so basically the extent to which that migrant rights are protected in laws, but also their de facto implementation, the extent to which they are actually implemented by governance. And then finally, we standardize all of this for aggregation across 36 countries and soon to be 45 countries. And really, that's quite an achievement as well, because as you can imagine, the different legal systems and statutes in place are very different across all the variety of countries in the world. And we were able to actually, from lots of piloting, fine-tune the code book so that it actually works across all the different countries that we study. So I'll hand it back over to Ian to actually discuss the results so you can see what we find.
Thanks so much, Justin. As we begin the results, let me just give you a visual here of the 36 countries that are account for, as I said, about 80% of migrant hosting jurisdictions or jurisdictions hosting about 80% of the world's migrant stock. And although we'll be taking up to 45 cases, we really capture a tremendous amount of the world's practice around migrants' rights already. So let me share some summary findings. And what we see here is those 17 categories or clusters of rights. As Justin mentioned, we have 65 indicators. And so we're grouping them in these 17 clusters. And you can see overall at the global level within those 36 country cases, how countries fared. So we see two columns here. The first is the average protection score. That's what Justin described as measuring the de jure. How does the law in these country cases stack up against the Bill of Rights in these areas of rights? And then the implementation score takes that coder evaluation of how often states comply with their formal legal commitments and puts that in a score. And so we see here a kind of hierarchy of national legal compliance with freedom of thought, conscience, and religion or belief as the area where countries are most consistently protecting migrants' rights in their national law. And you can see in the implementation score that it's reflected in about 3/4 of the time states complying with their own undertakings in the national law. Let me just offer some reflections about what we might find unsurprising or surprising in this overview. I think most importantly, these data suggest that there's some broad consensus among states that account for a majority of the world's migrant stock on key civil and political rights, on pathways to citizenship. So you see the nationality cluster of indicators includes questions about the availability of citizenship for family, humanitarian, and economic migrants. Second, there's very little reflection of there's not as much reflection of the protection against discrimination as you might like to see. That's we'll talk about that more in the last part of the talk. And finally, what might have been surprising or even more surprising before COVID are the limited protections of the rights to protection against expulsion, asylum, and non-refoulement there. Now, the indicators capture a range of issues, of course, as we discussed. But I mentioned earlier that in the first 6 months of the pandemic, about half of UN member states closed their borders without exception for asylum seekers. And so it may not be as surprising as we might have thought a few years ago that the formal legal system in many UN member states that host large numbers of migrants doesn't adequately reflect what we are seeing as the international baseline. So what we hope will be one of the big contributions that we'll talk about more over the course of the talk that these data can make even at this level of generalization, but also at the more granular level, is to identify clusters of rights where there is broad consensus. We hope that will start to make conversations around protection of the rights of all migrants less controversial in certain areas. And as I said, really, this is an area of governance and law where there's really been no data. So this provides the first effort at the global level to inform negotiations around international migration and to help show that in some areas of rights, national jurisdictions are actually protecting the rights of migrants. And we should recognize that, and hopefully that can make some of the negotiation around expanding protection in other areas less controversial, identifying areas of opportunity for advocacy. So let's move to the national level, what the data can show. This table represents the mean level of migrant rights protection in each country. So you can see in this chart that France leads the countries in our data set with about 85% of the indicators reflected in national law, followed by Brazil and Argentina. You can see Australia at the end. Just a note on the laggard, but something that those who practice in the United States or in other federal state systems may recognize that in some jurisdictions, there are key protections in place only at the subnational level, and our database only captures what is nationally consistent across a given country case. And so where there is significant subnational variation, as is the case in Australia, even if a right is protected in a small percentage of the jurisdiction, it's not enough for it to be protected in the database. So here is what we can produce with that implementation score. It's what we call our implementation adjusted score. We create that by essentially multiplying and combining the formal legal protection with the degree to which states implement it to give a more realistic sense of how we should adjust the protection score for the realities of implementation on the ground. And so here in this cut of the data, we can see that, again, this is the aggregated protection of all 17 categories of rights. So, we can see some subnational variation or some national level variation across some of those indicators. But you see here that Denmark, Spain, and Brazil reached the top of the list. Let me turn it back over to Justin for a little bit more on our findings.
Sure. Well, the next couple of slides just kind of offer a sort of visualization, a demonstration of what this data is actually capable of doing. So in the report that we're preparing, we're going to be preparing a number of case studies, country cases, so that we can understand those countries' protection of migrant rights more holistically. And a spider plot like the one you're looking at right now is a really nice way of visualizing that, where we actually plot the scores across 17 different scales related to the 17 different categories of migrant rights. And so as you can see here, this example is of the United States. The green area is capturing the de jure protections, the legal protections that are in national law and statute and case law. And then the red dotted line shows the extent to which each of those protections is implemented. And so note that sometimes you'll see the implementation score exceeding the green line. That's normal. That's okay, because it's showing you where implementation is on the implementation scale rather than on the legal scale. And so as you can see, the United States does a very good job of protecting vulnerable migrants' rights in a de jure manner, but the implementation is about halfway there. Meanwhile, you have higher implementation of religious rights or freedom to opinion, and also its coverage in law. So this is a nice way of looking at it holistically. Each country's shape, the form it takes on these 17 dimensions, is going to be different, but will be comparable across the different spaces. On the next slide, this is a visualization of effectively everything the database can do. And of course, I don't expect any of you to be able to read this very carefully in this particular moment, given the nature of this presentation. But this checkerboard, chessboard, airline board, whatever you want to call it, is a manifestation, is a visualization of each country's different aggregate total right scores on the far right, but also all of them disaggregated by category of rights. So whether they relate to labor or healthcare or opinion or family or asylum, each of these are captured now on the same graph, and they can be compared both by column in terms of the categories, or holistically and comprehensively at the end in the final column that's separated across country in total. So the database actually gives us a lot of different ways to present the data and to examine it. And these are all the adjusted scores that are adjusted for implementation gaps. Of course, you can do the exact same board for the scores with in their raw form if you're just interested in what national legal protections are there. Of course, with immigration, states say they're going to do a lot of things, but they don't actually always enforce it or actually implement what they say they're going to do. And for that reason, we think it's really important to both capture the implementation of those rights and also their protection in national statute. Back over to Ian to conclude things with the discussion of the compendium.
Thank you, Justin, and thanks everyone for listening through this presentation so far. We've covered a little bit about our framework and theory of change, dug in on this migrant rights database, which is a really unique and global, really a global first when it comes to empirics on national implementation of migrants' rights. And this next section to close the presentation is focusing on a new research project that's really an extension of the migrant rights database. And that's the project that we've been graciously supported by the Cornell Migrations Initiative to undertake, and will allow us to develop a new database And that will allow us to essentially create a kind of compendium or encyclopedia of practice to evaluate and justify how or under what circumstances we might think about the Migrants' Bill of Rights as providing evidence at the national level of the creation of customary international law. Now, customary law is a particular type of international law. The kind of casebook definition is law it's not written down. It's developed through the practice of states, and states recognize it as law and act in response to it as binding. So it's a binding but unwritten law. At the global level, when we look to the creation of customary international law and try to provide an account for how state practice is consistent with a theory that something might in fact be a customary international law norm, really looking at two different things: the practice of states, and then how states think about the bindingness, if you will, of those obligations. Now, you can already guess or see, I hope, that the way that the migrant rights database was built, including that it incorporated citation to law for the proposition evaluated by the national level coders, creates a way for us to jumpstart this kind of inquiry. And what it's going to allow is to look at that first category there of the practice of states. So I want to walk you through a little bit this idea with an example of the right to non-discrimination. So as we will discuss here, we're going to look at both the origins of this idea of migrant rights to non-discrimination as going back to the UN Charter itself, and also to human rights treaties, and then look at how international authorities have applied that to migrants. So here you'll see the evolution of non-discrimination law in the international system. You see in the first two rows of this chart the articulation of the relevant non-discrimination provisions of the UN Charter. So going back to 1951, you see a anchor recognition of the right against discrimination as part of the creation of the UN Charter regime. Then the articulation around the same time as the Universal Declaration of Human Rights notes a couple of important words here: national or social origin or other status. The Refugee Convention talks about discrimination in terms of country of origin. And then in 1990, the Convention on the Rights of Migrant Workers talking about nationality. So you see the key anchor here is that we have a right to non-discrimination that protects migrants in all circumstances, and that gives us one set of evidence about how the right of non-discrimination applies to migrants. What are the boundary or scope of that right? So that's when we move to another aspect of international law, which is the opinions of treaty bodies here that are interpreting the undertaking that states have created in the treaties that I just discussed. So here you have three different opinions from international bodies that are talking about how do we think about this right to non-discrimination and apply it to migrants, and particularly when we think about different migrants with different status, regular and irregular migrants. And you see the evolution here starting in 1986 with the General Comment 15 of the Human Rights Committee that interprets the International Covenant on Civil and Political Rights, saying that the general rule is that rights don't differentiate in their applications between citizens and non-citizens. But if you go and read the rest of the general comment or read the treaty itself, there are some rights that differentiate on the basis of status. So the most obvious of these is at the international level, the right to vote is reserved to citizens. But as those of us who follow New York City politics or the politics of the European Union know, there is some important progressive development here at the regional or subnational level in a lot of places, recognizing that the principle of political participation should not, in fact, differentiate on the basis of citizenship. Then you have 1989 making clear that discrimination is any differential treatment made on the basis of a prohibited ground impairing the enjoyment of rights, and then the Convention for the Elimination of All Racial Discrimination Treaty Body in 2002 making a nice clear statement that treatment on any basis, including citizenship or immigration status, can be discrimination if it's not legitimate, not applied pursuant to a legitimate governmental aim and not proportional to the achievement of that aim. So that's how international experts view this right of non-discrimination applying to migrants. But how do we think about how states look at this norm? And that's where the compendium will take off from the migrant rights database, build on that, and create a really exciting body of evidence for international lawyers and for states. So here's an indicator that we have in our data set. Does the national law prohibit discrimination against migrants on the ground of migration status? I have the basic results here. 20 states in the database of the 36 that we code does not have a national legal provision that prohibits discrimination against migrants on the ground of their migration status. 16, the answer is yes, although this is an area where that implementation score is revealing. It's only about 55% of the time. And I've given you in the slide here 2 examples of national legal provisions that come from the database. Mexico has a very robust articulation of this right, and Italy also has a very nice articulation. But I hope it gives you a sense here about how we can take the MRD, take the work of those coders and start putting it towards this challenge of evaluating whether and how state practice can be seen as consistent with those broader international norms and build a new kind of data set that allows us to evaluate this question. So the research design for this next phase will allow us to, as we go to 45 country cases in the migrant rights database, we're going to be recruiting a coder from each of those country teams to answer a supplemental questionnaire, building on the citations in MRD, and give us a more granular account of compliance with the IMBR and help answer that research question. So that's going to help us flesh out not just the evidence of practice that we've been discussing, give us more from executive, administrative, legislative, or judicial materials, but it's also going to allow us to incorporate any evidence that the practice consciously reflects a sense of obligation in the international baseline. So that's going to help us enlist these coders in key areas of rights to find out whether things like legislative materials or debates about executive practice actually discuss the international obligations or not. And that information for those 2 categories of evidence, again, is going to help us address this question of whether we have evidence of customary international law. And of course, when it comes to those treaty commitments that we've been talking about for the whole duration of the talk, this evidence also gives us really useful information in the compendium to address those norms. So thanks for your attention. It was really exciting for Justin and I to join you and to talk about this project, about how we've done this work, this normative work at the international level, and how we've adapted it into 2 really innovative research projects that we hope will help not just researchers interested in the nature of migration law and practice, students interested in studying it, but also law and policymakers trying to influence the way that countries recognize and protect the rights of those on the move.
Great. Well, thank you for that presentation. Very exciting. You've done a lot of great work. And let's start with the questions. If you do have any questions, type them into the chat or the Q&A, and I'll address them. One that's come in for both Ian and Justin is, how could somebody actually use this new database that you've created, both at an individual case level and at an advocacy sort of supranational level?
Why don't I take that first? So when we think about an individual case level, this is a place where the citation to the law can be really useful when we're thinking about case. And I immediately interpret that in the kind of lawyerly sense of, if I'm a lawyer representing a client in a particular national jurisdiction, I'm trying to get them out of detention. This database, because of the citation to law, creates an immediate comparative law tool for me to be able to go into the database and say to the judge, sort of setting aside the national law arguments that I might be making on behalf of my client, in addition to those arguments, you should know that 20 out of 36 countries that host migrants prohibit this practice or recognize the right of liberty and security of person in this way. And so, in that sense, when I think about individual cases and individual cases of migrants, that's an amazing tool, and lawyers around the world clamor for this kind of tool when they're doing their legal casework. When we think about the supranational level, one of the things that we're hoping to do to inform that global compact on migration that I talked about earlier is use this database to help those who are evaluating those commitments that states made. So to dwell too much on the global compact, but it is an expansive document with scores of practices that have been broken up into many different categories. And Justin and I have written about this precise question of how the MRD relates to that. So if you're interested in a longer version, you can read that piece in International Migration. But the bottom line is that because, as we've both shared, there's really no data baseline for these questions. When states think about how they're going to do better by migrants, those states that are trying to do better by migrants, giving a kind of cross-national data case for how a particular issue is reflected in national law, we hope will help the UN delegates spur states to do more. So if you just take the issue of detention, it's an area where we and others were able to get the Global Compact to be fairly robust. And we think that providing more granular information about how the national framework touches on detention will help civil society and help progressive states push more states to do more to regulate detention at the global level.
Justin, do you want to add anything to that?
No, I mean, Ian really understands the advocacy space the best. And so I think he really did a good job summing it up.
Great. A technical question, maybe if you can start on this one, Justin. How do you assess implementation? If there's a law in the books, how do you measure the extent to which a country actually is implementing that statutory law? I would think that it might vary a lot from country to country.
Not just from country to country, but from lawyer to lawyer. And so this is by far the most subjective component of the database, but nevertheless one that we're sort of accepting with its evils. So while we can cite statute when we're actually coding the laws, it's really hard to sort of, you can cite evidence of implementation or lack thereof, but it's not necessarily going to be anything more than an anecdote. And so in this case, what we do is we rely on the expertise of these lawyers who practice and follow the laws on an everyday basis to actually share their subjective interpretation of the extent to which these laws are being implemented by the government. Now, the good news, of course, is that we're not just relying on one coder, we're relying on two. And what we do is we average their scores unless they are really, there's a significant discrepancy between them. And when there's disagreement, we basically have them resolve it and intermediate. So this is definitely the most subjective component of the database, whereas the de facto scores, which we purposefully present separately, are rock solid. The implementation scores are going to be subject to some implementation.
And a related question that came in, the pandemic. When you started this research and the database research before the coronavirus pandemic, the pandemic obviously changed government's implementation of migrants' rights to both enter or be detained. How has the pandemic changed some of your answers? And then I have a second question about how could you use your database from an advocacy perspective and sort of arguing against restrictions on migrants' right to enter a country, even during the pandemic?
Well, I'll let Ian take care of the question about advocacy. In terms of the pandemic, this is a very important question, and it really is the motivating question behind the second wave of our study. So as Ian clarified, the first work we undertook here was on 36 different case countries. We're now broadening that to 45 different case countries, which will be coded about 3 years apart. And the 3 years that they'll be coded apart really subsume the pandemic period. And hopefully that's as far as it'll last. But what that means is we'll be able to have a before and after photograph of each period so that we can better understand what was the effect of the pandemic on national legal protections for migrant rights. And so we really don't know exactly what effect the pandemic has had empirically. Now, in terms of our priors, we do have some expectations. We think that the pandemic was actually disastrous for the implementation and the protection of migrants' rights. Of course, a pandemic sort of invokes people's worst fears of contagions coming from abroad. And of course, that is precisely what has happened with the pandemic, is that the globalized nature of the world has led to its global spread. And so it's very likely that we're going to see a lot of backlash against immigration, and it could take the institutional form of laws, statute, case law that rules in a much more restrictive manner. I'll turn things over to Ian to discuss these points some more, but also to talk about the advocacy perspective you mentioned, Steve.
Yeah, thanks. Great set of questions, and we're really excited to be able to come back in a year or two's time and report on the more granular picture that would come from that recode of the data and the expansion to 45 cases. The reality, I think, in many country cases is that the changes, at least in the initial period of the pandemic, were made through discretion and loopholes or changes in the law. It changes in practice rather than changes in the law when it comes to the protection of migrants' rights in the time of the pandemic. And so it'll be interesting to see also how that implementation score is modified, even if the actual formal law might be similar from before and after the pandemic period. Whether the implementation, as Justin said, shifts substantially. I think from an advocacy level, this is a place where we see the data to be very, very useful to debates about migrants' rights. And so, in the pandemic, there was quite a bit of collaboration at the international level around calling on states to implement a moratorium on the detention of migrants. I think if we had had a more granular picture about how the national legal systems in most migrant receiving states already recognize certain core rights of migrants in the context of detention, we might have been able to be more robust in the specificity of the demands on states to get them to uphold their own commitments and to apply the basic norms around detention to the context of COVID-19. There was a lot of agreement among international legal experts that the context of COVID and detention made detention unlawful for migrants, detention on the basis of migration status, because it made the risk inherent in the contagion and close confines of detention just made that as a state response to migration control disproportionate. And if we knew more about what the national legal frameworks were, we might have been more effective in our cross-national advocacy.
And Justin, picking up on something you said about xenophobia, your new book, Majority Minority, touches on that. How has this research sort of affected your book writing or theme in that book?
Thanks, Steve, for that question. Thanks for noting my new book. It's all certainly correlated, and it's all mutually reinforcing. The pandemic and the sort of the status of migrant rights is very much conscious on people's minds when we see this sort of xenophobia as a form of backlash to the rights that many people of immigrant origin have been actually bestowed. And so I think that this project, of course, does not deal with political behavior or public opinion, but as we all know, the pressures that actually lead to the creation of these rights in the first place in national law are the product of public pressures that come from public opinion. And I think it's beyond a doubt at this point that many countries, many governments have become shyer and more timid in the protection of migrants' rights in the face of a wave of populism and nationalism that has arisen across a number of countries that are principal destination states in the world of migration. And so, these kinds of pressures are going to remain persistent, I think, as countries kind of grapple with their changing demographies and what that means for their politics.
One question that's come in concerns the second part of your presentation about discrimination and the compendium on that. How do you measure discrimination, and how could somebody sort of research this in more detail? Is your report public, for example?
Well, this is precisely actually one of the reasons why Ian is taking the lead on organizing the compendium. So I'll let him answer the question. But by just to preface it, by looking at the level of a certain indicator or of a certain topic, the compendium will allow people to effectively double click on the matter of concern, while at the same time contextualizing it in the greater database. Ian, over to you.
Yeah, it's a really good question. I think one of the things that I didn't mention, not because it's not extremely significant or didn't highlight, I guess, is, of course, when I started with the UN Charter framework and highlighted some of the treaty language, I was really focused on differential treatment on the basis of migration status, the discrimination against migrants qua their migration status. But of course, the right to non-discrimination, as the language on that slide suggested, is varied and significant, of course, relates to racial discrimination, discrimination on the basis of ethnicity, and many other grounds. So our indicator that I highlighted focuses really on just that one aspect of status as a foreigner or as a non-citizen. And so that's how we measure the implementation of that particular norm, is to look at how did this national law stack up against that commitment? And then with the implementation score, how often are states complying with that commitment if they have one in place? So that's the way that we try to measure. And Justin talked a little bit earlier about some of the complexities of that implementation score. And certainly, if you were interested in researching this issue further, what we hope is that the compendium, as Justin described, would be kind of the first step, because that would allow you to think about, okay, I want to focus in on this right to non-discrimination on the basis of migration status. First, let me look and see what the treaty law says about this. Then let me look and see what international law experts have said about this. And then let me go to a particular national jurisdiction and see how the national law and practice has taken this issue on. And it's the ability to really drill down from a lawyer's perspective, drill down into that national practice, and then to telescope out to the different country cases that is going to allow us, really for the first time with the MRD and then the compendium together, to really talk about how concretely a given right is implemented at the national level. It gives us a really exciting new tool to think about this question across country cases, and then also at the international level. Of course, it's very important what international authorities say about these rights, and it's important that states have made these commitments. But what we're going to be able to do is add that national practice dimension to this discussion, and really give both researchers, but also advocates, migrants themselves, the ability to hold states' feet to the fire and say, hey, in this database, it's really clear that you are far afield of your international commitments, and we want you to do better.
Another question that came in is, can I see your database now? If I'm litigating a case in U.S. court on Title 42, for example, can I see what you found from what other countries have done in terms of excluding migrants during the pandemic?
Well, so we're always happy to get queries from advocates on this. Our indicators do not capture the particular specificity of denial of the right of access to territory for asylum seekers in the context of a global pandemic. We're perhaps not that granular or prescient in our thinking when we designed the indicators. There is a very useful data product out from UNHCR on this issue of border closures and right of access. That's a fabulous data resource that I can try to provide the link in the chat, but folks can also Google around and take a look at it. But in this question, hopefully you won't have to wait too long, because one of the pieces of our expanding the data set to 45 countries is that we've also received support from the Swiss to make this data public in a way that's going to be easily accessible by researchers. So by the end of, certainly by the end of this calendar year, we should have a very nice data visualization up that will allow researchers and advocates not just to drill into the data and to get at it, but also to visualize it in a way that should help make some of these comparisons that we've been talking about come alive for you on the web.
Another question that came in, it's a little more off topic, but maybe you can try to answer it. The question is, from a policy perspective, what are your thoughts about increasing the number of H-2B visas. And for those who don't know what those are temporary visas issued by the US government for non-professional temporary workers. That related all to either of any of this presentation?
Well, I actually think that, Steve, you're the best person to actually ask that question. Just to clarify, our work is looking at rights across people's, different visa classes, countries of origin, motivations for their migration. And so we are concerned with universal protections of migrants' rights. We do actually code if there are partial protections subject to visa classes. And so, in some cases, certain rights are protected for people who are on permanent visa tracks rather than temporaries. And in many cases, as Steve, I'm sure you can actually, and I hope you will, take this opportunity to share your expertise. As you know, people who are on temporary visas often are not subject to those same protections.
Correct. And I think that's questioner's question was really more, will additional visas help? And I think it's more of a labor shortage question and not really related to your International Migrant Bill of Rights question. But 20,000 visas is pretty tiny in the grand scheme of things in the US workforce. And we have a serious labor shortage problem, but every little bit helps. So that's something that the Biden administration could do without having to go back to Congress to add additional visa numbers. So that's why they did that.
And it's also, one of the ways that a lot of countries that are hamstrung by public opinion and xenophobic public attitudes, it's one of the ways that those countries have actually broadened the reach of the scale of their immigration programs is by leaning on temporary migration, because they're able to ensure or I should say reassure skeptical publics that the immigration that is coming in is not going to be permanent. So, we are seeing that in a number of countries. And I would say perhaps the best example of this is Japan, which is notoriously, xenophobic and isolationist when it comes to immigration, but has actually embraced new forms of temporary migration.
Great. Well, we're almost at the end of our hour. Why don't each of you sort of say what's the one or two things that you hope the audience takes away from today, or that you hope to achieve over the next year through this research? Justin, you first.
Well, I think that we have both a scholarly approach to this work, in the sense that we want to better understand what brings about change and what actually drives a greater protection of migrants' rights, which is just such an important area of interest at the global level. But also, I think, I don't think our work would be complete if the work was not actually applied sufficiently to be of use to the activists and the lawyers and the politicians, the policymakers who are trying to advance migrant rights. And so, I think that, I hope that this project is a sort of model of where both scholarly interests and the public interest can overlap in a way that you can maintain scholarly, standards of objectivity and standardization, but at the same time really affect change, in this case at the global level, but at any level really of the public sphere.
Ian?
Yeah, I will just share one other aspect of the history of this initiative that I didn't mention earlier in the talk, but because I know we have a lot of Cornell students listening, and I hope students from other institutions. This started initially as a project in a class and a collaboration between students at several universities, including some of Justin's students at the LSE. And it has grown from that collaboration, kind of, really pure research puzzle that students took on with their enthusiasm and energy more than a decade ago. And it's still going. So I think, maybe the secret other lesson of this talk is one of empowerment for students, but of course for anyone who's doing work on migrants' rights and of the power of research and work and collaboration to create, in this case, we hope, a set of research and advocacy tools that's useful public good, but also pushes the envelope and helps keep states accountable.
And that's a great way to end this, an optimistic point. And thank you very much for both of you for all this great research you're doing, and to the Migrations Initiative and Cornell University and George Mason for sponsoring this research, as well as the Swiss government. It's very important research. This webinar will now conclude. It is being recorded, and people who want to see the URL afterwards can log into eCornell at the same URL and get it. And thank you very much for today's presentation.
Thank you.